Welcome and thank you for attending Sutherland, Asbill & Brennan, LLP's webinar, Current Update on IRS Appeals Division and Other Acronyms, including AJAC, RAP, ADR, and NII, and presented by Sheldon M.K. and Troy L. Olsen. Please send any questions via the dialog box located beneath the dialog player. CLE evaluation forms and sign-in sheets will be sent to you after the webinar. I will now turn you over to Troy L. Olsen.
Well, welcome everybody. Thank you for signing up to participate in this webinar that Shelley and I are doing on appeals. We're just going to start off by introducing ourselves. So my name is Troy Olsen. I have been with Sutherland for the last 7 years and practicing in the tax controversy area for over 10 years. I have a lot of experience practicing before the IRS Office of Appeals and a lot of experience also litigating cases that were not able to be resolved at appeals, or some cases where we just determined that we were going to bypass appeals for various reasons. I also spent some time working as an attorney advisor for the National Taxpayer Advocate, and that will actually play into a little more of what we're going to be talking about today as I relay to you the story of the independence of the IRS Office of Appeals. But that's my background, and I'm also here with Shelley K.
Yeah, hi, this is Shelley. I started out working as a CPA, and then after I graduated law school, I went to work for the Internal Revenue Service Office of Chief Counsel, and spent about 18 years there, litigated many, many cases, taught courses on how to litigate cases, how to do discovery, etc. Then I went into private practice with one of the big 4 accounting firms, and then for about 6 years. And then about 6 years here at Sutherland when I was requested by the then Commissioner, Doug Shulman, to come on board as a senior executive for the Appeals Division, which I did between 2011 and 2013. I was the deputy and then the chief of the Appeals Division for the IRS. Retired last August and came back to Sutherland. Now, for anybody who's interested, the recording of this will be available on our website. So you can either email us if you want another. If you want to get a copy of this, or just go onto the website. So if you know anybody else who wants to hear this, or you like this so much you want to hear it again, it'll be on our website that you can view. We're going to cover some various topics today. We're going to cover just generally what appeals mission is, its structure, its some basic statistics. Going to talk about AJAC and changes that are being made and have been made to the ADR process, the appeals, rapid appeals process, or RAP, the new information initiatives, and then when it's all over, Troy and I are going to give you guys some real practice tips. So, if nothing else, you will get out of this webinar some real useful and helpfully useful tips that you can use in your practice. But just so we can get an idea as to the experience level of those who are out there, can we see that first poll question?
So it's on the slide, and then it should be coming out to you so that you can vote. Also, I will note I am in charge of advancing the slides today, so if there's problems with that, don't blame Shelley, and you can send a question in, like move to the next slide, Olsen.
Okay, well, it looks like we got almost 20% of our folks have got a lot of experience, or and then another 20 or so have some experience. The majority of the folks have very little. And it's luckily very few people don't even know what appeals is.
Yeah.
So that just gives us an idea and you guys an idea for who's out there. With that, Troy, why don't you talk a little bit about the appeals for the mission for appeals, because its mission is different than the mission for the IRS, and that's not really known that much by both practitioners, and I got to tell you, a lot of folks at the IRS don't really understand or appreciate or know that there is actually a difference between the appeals mission and the IRS mission.
Okay, so let's the slide there that I hope everyone can see lists or restates the mission for appeals. What you don't have on your slide is the mission for the IRS. I'm going to read that to you. I know everyone's taking copious notes, so I'm sure you'll write this down. Here is the IRS mission. The IRS mission is to provide America's taxpayers top quality service by helping them understand and meet their tax responsibilities and by applying the tax law with integrity and fairness to all. There's some similarities there between there's some similarities between the IRS mission and the appeals mission, but there are also some significant differences. So let's hit the appeals mission here, and that is to resolve tax controversies without litigation, which I think is a key phrase, on a basis which is fair and impartial to both the government and the taxpayer, which I think is another very key phrase here in the mission. Then it goes on to say, and in a manner that will enhance voluntary compliance and public confidence in the integrity and efficiency of the Internal Revenue Service. So the differences are, for those of you who did not write down the IRS mission statement, appeals is here to resolve tax controversies between taxpayers and the IRS without litigation. That's really, I view that as one of the core missions of appeals, is to try and avoid litigation when there's tax disputes, but also to do that on a basis which is fair and impartial to both the government and the taxpayer. I think sometimes taxpayers believe that the mission of appeals should be to do that on a fair and impartial basis to taxpayers only, and I'm sure on the other side, folks believe that appeals should, as part of the IRS, they should be kind of standing up for IRS enforcement and compliance. But those are the missions of the IRS and appeals.
Right. There's a stark difference between trying to have somebody understand and then meet their tax responsibilities, as opposed to trying to resolve cases on a fair and impartial manner. And that's key. And there's a key difference there that we'll go into in a little bit more detail. I don't want to spend a whole lot of time on the statistics, but I thought I'd just give you guys a quick overview as to what's happening at appeals. As you can see, their staffing has been decreasing year after year for the last 3 years, and it will probably be decreasing again this year. The budget for the IRS, actually for the entire government, including the IRS, was passed at a level consistent basically with last year. And the last that we heard, the IRS is intending to, and the appeals included, hire one person for every 5 people who leave. So with attrition the way it is, that the number of folks working for appeals will more likely than not be decreasing throughout the year. The good thing is that the receipts are also decreasing. And if we quickly look at the next slide, when you look at the kind of cases that appeals gets, prior to 1998, the appeals almost never got any collection cases other than, a trust fund recovery cases. Now, if you look at it, actually, those are over half of the cases that appeals gets. Those cases don't take as long for the appeals to work per case, but there's just a large number of them. But if you can see there's a fairly dramatic decline in the collection due process cases, and that's due to several matters. I mean, for example, the IRS has indicated has started a Fresh Start initiative. That has clearly reduced the number of CDP cases. The economy is picking up a little bit, so fewer people are unable to pay their taxes. So, I mean, there has been a fairly substantial decrease, especially in the collection cases that appeals gets. And this next slide, we just wanted to make sure everybody has a who's who as of appeals as of today. These are all the folks. There's one vacancy in the executive level for the campus operations, but these are the folks that you'll be dealing with at appeals. But Troy, what do you think independence means? I mean, you mentioned that before when you're talking about the mission of the IRS. What does their independence mean to you, and why is it important anyways?
Okay, well, I think what it means to me, it means a lot of things to me. I think the best way for me to talk about this is to present it in the form of a story, and we'll get to that later in our practice tips. But the kind of the saga of appeals independence, it goes back a ways, and we'll start off not too far back with the IRS Restructuring and Reform Act of 1998, also known as RRA 98. Now, I don't think 98 is too far back. I still like to have several days growth on my face, throw on a flannel shirt, and cruise the neighborhood listening to Pearl Jam. But it turns out that that's actually about 15 years ago, and that's probably why my kids discouraged that behavior. But back in RRA 98, Congress actually mandated that the IRS ensure an independent appeals function within the IRS. That's a key phrase because some of the other proposals at the time were suggesting that appeals should move outside of the IRS, but that's not what happened. Within that includes the prohibition of ex parte communications between appeals officers and other IRS employees. We'll talk more about that particular aspect in a minute. Some more key language here. To the extent that such communications appear to compromise the independence of the Office of Appeals. That word appear is very key here, and it's very key that it's actually in the statute. In 2004, I was working at the Taxpayer Advocate's office, and some of you might not know that one of the roles of the National Taxpayer Advocate is actually to issue a report to Congress every year that does a lot of things. In fact, most of these reports these days are about 700 pages long. But a fair number of those pages include what are called the most serious problems affecting taxpayers for that year. As you can imagine, some of those would include things like complexity of the tax code or getting rid of the AMT or things that affect taxpayer rights. Well, one of the most serious problems that I worked on when I was there back in 2004 was labeled independence of the the IRS Office of Appeals. In other words, in the mind of the National Taxpayer Advocate, one of the most serious problems affecting taxpayers that year was that the IRS Office of Appeals was not independent. Now, what we were really saying is that the perception out there was that appeals was not independent. When we looked into it, we were looking at a lot of IRS customer satisfaction data. We were looking at information that we had been receiving from taxpayers and practitioners. And the main thrust of our report is the perception of independence is low. When you don't have the perception of independence there, appeals mission's thwarted because folks just aren't going to use it. In response to that report, appeals itself actually asked the Treasury Inspector General to do an audit of its independence. And in the next year, 2005, TICTA issued a report that it concluded that that appeals overall independence was sufficient, but they did include some suggestions for improvement, including some more guidance with how appeals independence was going to work with some of the appeals ADR programs that were being rolled out at that time, and requesting additional guidance on how ex parte communication should work in these kind of innovative programs that were coming out. The next thing that happened was in 2007, the ABA tax section sent out a survey to its members asking them what their perception of IRS appeals was. Although it's not a scientific poll, they did get substantial feedback on the poll. There were 560 tax section members that responded, and they received 70 pages of comments. The comments and the responses were pretty much along the lines of what the National Taxpayer Advocate report and the TICTA report had said, and that is that the perception of independence wasn't quite there. The experience with the appeals officers was that they were fair, that they were smart, that they knew what they were doing, but they were hoping to get some additional guidance when it came to particularly ex parte rules. Which brings us to the next piece of the story where Shelley comes back in.
Well, and actually, having those things in mind when I went back to the service, that gave rise to several of the things we're going to be talking about today. I mean, that gave rise to the Appeals Judicial Approach and Culture project that was started, or AJAC. That gave rise to the service finally coming out with their ex parte revenue procedure. It was something that in every town hall that I did with appeals folks, I stressed it. Every meeting I had with the executives for the business units, it was stressed about the appeals independence. And the last 2 years that I was at the IRS, we actually had zero most significant problems from the National Taxpayers Advocate's Office, which made it a lot easier for me to do the rest of my job. But that leads us to, what is an ex parte communication? And actually, just a quick thing. There's several people that have had questions about, can we get copies of these slides, et cetera? And the answer is yes. We'll have copies of the slides available on our website after the program today. So with that, these ex parte rules are not the same. So if anybody is practicing as an attorney and you know the ex parte rules before court, these are different. These are substantially different. They're meant to preserve the independence of the appeals process, not any judicial background.
Yeah, right. So as you can see how we've defined it on the slide, and this is actually defined in the guidance and defined all over the place, it's communication. It's a communication that takes place between any appeals employee and employee of other IRS functions without the taxpayer and the representative being the opportunity to participate in the communication. So like Shelley said, unlike in the judicial context, in appeals, the taxpayer can talk to the appeals officer or all he wants, or all she wants. The practitioner can talk to the appeals officer all day, every day. I'm sure that's what the appeals officer is just waiting to do, to talk to practitioners all day, every day. But on the other side, these rules do prohibit, with numerous exceptions, but the general rule is appeals officer cannot talk to enforcement compliant folks that are involved in the particular case without the taxpayers having the opportunity to participate.
Yeah, what's important there is, they're allowed to have these communications. People think that they can't talk to chief counsel folks, or appeals can't talk to the compliance folks. But that's not true. They really can, but they have to offer the taxpayer the opportunity to be there. So, before the 1998 Act, the LB&I, it was called large case at the time, used to have the pre-opening meetings with appeals before the appeals process would start, and taxpayers weren't invited to those. And so a lot of comments were made, and it's very difficult to know what was said at those. So part of the goal of the ex parte is to make sure that the taxpayer knows of what compliance or counsel is saying and can respond and rebut to what they're saying. And guidance came out back in 2000, a Q&A. It had like 40-something questions and answers. And I tell you what, every time I looked at it, I had more questions when I was done reading it than I had before I went into reading it. So we completed when I was at Appeals a project. I mean, they had been working on updating the revenue procedure for somewhere over 6 years, and we actually ended up finalizing that in RevProc 2012-18. Made a lot of changes, made better definitions, raised the level of who makes a determination of what the remedies are and how they will be affected with that. And why don't we put that next poll question up?
New poll question.
Okay, you get an ex parte breach. Do you get a tax credit, or you get a percentage off of your taxes? You get the right to challenge the interest. Criminal charges for the offending IRS folks. A transfer case. What do you guys think?
Looks like the voting is going on. According to the screen that we're looking at, is that you're all still voting. Okay.
Okay. Nobody wants to put them in jail. Everybody pretty much thinks that there's no specific remedy and they can have the case transferred. And actually, the right answer is more E. D can be right in some cases. And what was done is, in order to make it more nationwide and uniform application, the revenue procedure raised the level. So now the decision is made by the area director. So it's not the appeals officer or settlement officer. It's not their manager, but it's their manager's manager, to try to make sure that whatever is going to happen as a result happens. And basically, what they try to do is try to figure out what needs to be done to put the taxpayer in the same position they would have been had there not been a violation of the ex parte rules. And that is oftentimes providing the taxpayer with the content of that communication, giving the taxpayer a chance to rebut or comment in any manner whatever was told with them. In certain circumstances, that it may be necessary to have the case reassigned. In some cases, it could be reassigned to a different office even. But that's something that, again, it's raised to a higher level. It's raised to a senior manager level for them to make that determination.
Yeah, I actually purposely threw in sort of a trick. The response to D was a bit of a trick because I said the right to transfer the case to another appeals employee or office. So the guidance, the 2012 guidance is very clear that a violation of the ex parte rules does not give any substantive rights to the taxpayer. But as one of the remedies listed, it does list, or it does say that a possible remedy could be in particularly egregious cases to transfer the case to another appeals office or another office. Now, the appeals independence saga just won't die, sort of like George Lucas has taken over it. And we have more stuff that Shelley was really involved in when he was at the IRS here called Appeals, Judicial Approach, and Culture. So he's going to talk a little bit about the genesis of that.
Yeah, actually, in my discussions that I had with practitioners as well as at town halls that I had with the appeals officers and settlement officers, one thing was made pretty clear. The practitioners thought that appeals folks were just being compliance part two. They were finishing the investigation. They were analyzing the facts that they were getting themselves and basically doing what was being done by the exam folks or collection folks. When I spoke to the appeals people, they thought that the files they were getting from collection and examination division were not final. They weren't finished. That they just pick the exam and pick up the next case and throw the old one over to appeals, figuring appeals would finish it. So I worked closely with the commissioners for LB&I and SBSC and W&I and the Chief Counsel's office to come up with this appeals judicial attitude and approach, which basically is a fairly substantial change in the paradigm for appeals, and it should clearly result in a higher perception of appeals independence and put them in a position as, I used to tell the folks when I used to go around, like, think of yourself and ask, what would a judge do? A judge wouldn't go out and gather their own information. A judge takes the case as it's presented to them and makes a determination based upon that. Appeals officers are not supposed to be investigators. Because it's really hard. If you try to find out what the facts are, you find out those facts. It's really hard to be impartial when you're analyzing the importance of those facts versus the facts submitted by the other side. So what we try to do is have appeals folks be tasked with weighing the facts and arguments submitted by IRS and the facts and arguments submitted by the taxpayer and try to come to that resolution that's fair and impartial. I tasked the team there of managers, senior managers, and frontline employees, and they came up, and folks, actually somebody from SBSC and a counsel attorney, and they came up with like 29 recommendations, of which I think 22 of them were accepted. And I think the interim guidance came out back in July 18th of last year, and there's also been a change already in the policy statement covering this. And most of the changes actually deal with collection. We'll cover those in just a minute. But there's a few that deal with examination cases. Appeals is not going to raise new issues, and if you've resolved an issue at exam or collection, the appeals is not going to go back and reopen that and examine to see if really that was the best settlement or something different could be raised. However, if a case is in court, for example, tax court, Chief Counsel's office can still raise new issues, and if they raise a new issue, appeals will consider that if they have settlement jurisdiction under Rep. Proc 8724.
And then don't they have the burden of proof on that if they raise a new issue to counsel?
Yeah. The IRS will have a burden of proof on that. But one key question is, whether something is a new issue and a new argument. They're still working on that manual revision. It's not out yet. It's not a black and white question. There's no definitive answer. One thing I always look at: do you need new evidence? If you need new evidence, new facts, new witnesses, new documents, there's a good chance that might be a new issue. If all the facts are the same and just a different aspect of looking at the same type of matter, that could be a new argument. But hopefully the IRS will come out with its manual change on that shortly. But it does centralize the dissent procedures. What would normally happen, and this is to answer one of the questions that somebody already sent in, where cases get sent back from appeals to compliance, that should rarely happen now. Unless the taxpayer provides new information. If there's no new information provided by the taxpayer, appeals should take the file as they get it. Now, if there's a systemic problem, so that appeals notices that all the cases out of San Francisco on innocent spouse, for example, something's missing, they'll deal with that systemically. They'll deal with the commissioner of SBSE, the commissioner of WNI, and try to deal with that on a system-wide basis, not on a taxpayer-by-taxpayer basis. So, that particular taxpayer may get a fairly good result because, if the exam or collection didn't do their job properly, the file's not set up right. But you should very rarely get a case that's being sent back to exam or collection unless the taxpayer provides new information. And we'll get into that when we talk about the new information initiative in a little bit.
Skip to the collection.
You want to talk a little bit about the collection?
Yeah, so I think Shelley mentioned that in the new guidance that came out back in July, it's 30-something pages long, and 7 of those pages deal with changes to collection. I'm not going to go over every bullet point there. You can read that, but I think, again, in my propensity to tell things in the form of a story, a lot of the recommendations here, the changes in collection because of AJAC, result from not necessarily these cases I'm going to talk about, but the type of stuff that was going on in these cases. So there's a couple of cases in the tax court that came out within the last couple of years, and the name of the case is not Zillow, but they involve that website Zillow that you can use to kind of get a rough estimate of your real property. I think it only applies to residential real property. But in one of the cases, it involved a couple of older taxpayers who had run into some tax trouble, couldn't pay all their tax liability, had submitted an offer in compromise. They had submitted their financial statement with that, as you have to do in the offer in compromise, and along with all the supporting documentation, and included in that was a value of, or the value of the real property that they own. It went into collection, and then collection asked for some additional information. They had, based on their research, discovered that these people owned a couple of additional pieces of real property, and the taxpayer said, well, we didn't report those because, one, both of the properties are underwater, meaning that they are worth less than is owed, not that they were literally underwater, and two, they are in extreme disrepair, so it's going to cost us a lot of money to fix those up, so they're worthless. We didn't include those in the financial statements because the IRS is not going to be able to get anything out of those. Well, collection documented that, included the values that the taxpayers gave them, submitted it on to the settlement offer, or the settlement officer in appeals to process the OIC. The settlement officer took a look at the file and said, wait a minute, I don't agree with any of this stuff. I think that all these real properties should be worth more, so I'm going to use Zillow to determine how much these things are worth. So she got herself a Zillow Zestimate and changed all of the taxpayers' financial information. So basically what she did is the settlement officers, I think almost all the time, are former revenue officers. She got the information, and rather than looking at it as an impartial determiner of the fact and making a decision, she decided that she was going to work the case like she was an RO. The court found that that was an abuse of discretion, and these AJAC rules address that type of practice in appeals by prohibiting it. The appeals officers now are really not out there trying to develop new facts. And I mean, another helpful piece here is that very first bullet point where it says that when a collection information statement or a financial statement comes in, those are good for 12 months. I know I've been involved in collection cases where it seems like every time you get a new person, they want the taxpayer to fill out a brand new collection statement.
Well, they did, and that's one of the things that we looked at when I was there. I mean, it was an automatic. It was a way to get their first letter out. They would get their letter out, and in their letter they would ask for a new financial statement. Which a taxpayer, I mean, it's not that easy to do those. I mean, you have to go back with your several months of bank records. I mean, it's not all that easy for people to actually prepare those, and to ask them to do it again and again is really not right. I think, you just ask them, has anything changed since you last submitted it? And if they lie to the appeals officer, well, that's a felony.
Yeah.
And if they don't lie and things haven't changed, well, then you already have your financial statement. So this should speed up the process. It should make it a little bit easier and less burdensome for taxpayers who have collection problems.
So let's move on from the collection piece and talk about something that Shelley alluded to earlier, the new information initiative, and he'll talk about that for a second.
Yeah, it's really up for the compliance folks, SBSC and LBNI, to gather the information and raise issues, and it's up to appeals to try to resolve matters. And it turns out, as a lot of you may know, that a lot of people wait until they get to appeals to turn over new information. In fact, surprisingly, I mean, I was in Charlotte, North Carolina, speaking to a group of like 450 to 500 practitioners, and the person that was speaking just before I did was talking about offers in compromise and how to deal with the collection division. And he said that his goal is to not provide any information or as little as he possibly could to collection and wait till you get to appeals. Feign cooperation, kind of move things around, but try not to give anything till you get to appeals. Well, I kind of wondered if you looked to see who was after him on the agenda, because when I got there right after him, I said, well, I wouldn't necessarily recommend that you do that. And this new information initiative is something that appeals and LB&I were working on, that if new information is provided by the taxpayer after the case got to appeals, appeals will get LB&I's input. They'll either send the case back with that material, they'll send that issue back, or they'll at least send that fact back and let LB&I analyze it and provide their input, so that appeals is still, again, acting like a judge or a quasi-judge, where they can look at the input from the LB&I, look at the taxpayer's input, and then try to come to a mutually agreeable solution. So what this really means, as I tell everybody, is that any information you need to prove an element of your prima facie case for any issue that you have should be provided to appeals. Should be provided to examination up to the protest. If you haven't given it to them before, at least put it in the protest. That gives LB&I a chance to respond to it. If you do it after the protest, the new information initiative, which is still, the details are still being worked on, will come into effect, and appeals will get the input from LB&I on that information, or have to send the whole case back, or at least that issue back. So it's vitally important that you make sure that all the information that is requested is turned over as soon as possible. Okay, we've got a couple of questions that have come to. Let's see, we have one of them here. During examination, we have only provided information actually requested by the IRS. Does this new policy on not raising new issues and no referral back to exam unless new information is provided by to appeals by the taxpayer cause us to revisit the strategy and instead disclose all information during exam that supports the taxpayer's position in appeals, whether requested by exam or not? Well, I can tell you what my position is on that. I think that whatever you need to establish your prima facie case, the facts are what they are. I think you provide that, you set it up in your analyses, if you got a pretty good case, the fact that you provide it to them when they didn't ask for it is not a detriment. Troy, what do you think?
Yeah, so I think my thoughts on this are, Because I also do a lot of litigation. I think sometimes it's hard to separate the appeals arena from the litigation arena. In litigation, when you're in discovery, I think that kind of the general best practice rule is to answer the questions that are asked, because you rarely are going to, if ever, are going to be able to win a case in discovery. Maybe a little bit different here. If you have favorable information that you want to get out there and you eventually want the appeals officer to know, in light of this new policy, I think it would make sense to put that information in an IDR response or to get it before the exam team somehow so that it's in the record and you don't run the risk of getting before appeals and having the AO say, this is new information that I can't consider back to exam with you.
Right. And we have another question saying that they've experienced on more than one occasion hesitation from an appeals officer to reach a decision due to concern over the criticism or blowback from exam. Is appeals losing its independence, at least informally, if not officially? And what recourse does a taxpayer have if appeals officer is unwilling or afraid to assert their independence? And this kind of relates to the centralized dissent, and also relates to the dissent process in general, especially for LB&I, as to what is discussed after a case is finished. And the ex parte rules specifically state that discussions between appeals and LB&I after a case has been settled are not subject to the are not subject to the ex parte rules. And I just had a discussion this week with one of our clients on this, and I indicated to that person that I will probably include a comment on that in an upcoming article that I have coming out, because I think, just like taxpayers are now able to come to the pre-opening, there really is no reason why the ex parte rules should not apply to a post-closing, because if you get that case back with the same appeals officer, it would be good to know what was said, and even if it goes to a different appeals officer, you'll know what examination's position is on that. So don't know if that's going to change anything, but look, this way you look forward to one of my new articles coming up in a little while, so be on the watch for that. Okay, I think we got our last poll question. Which of the following appeals programs have you participated in?
Looks like you're all voting. Well, did we get a response?
So far, everybody's done a traditional appeals, and no one's done anything else. Well, that's great. So then this next part of this segment will be great for everybody, because this is going to teach you guys a whole lot of things about some of the various new and some not so new procedures that are available. One thing before I forget.
Oh, here's some updated results.
Okay, never mind that.
It's still not a lot of people. Sorry, folks. The slide is kind of going in and out. So.
All right. Well, first off, in order for you to get a CLE credit, when you go online, you're going to need the password, and the password for this session is appeals, APPEALS. Okay, let's go to the next slide. We'll talk about the Rapid Appeals Process, or RAP.
All right. And it looks like 5% or so of you have participated in the Rapid Appeals Process. Now, in working with Shelley to get this program put together, I did not know that RAP actually has been around for 10 years. It's been in the news a little bit the last couple of years, and we've also had clients that have been working with appeals folks that have suggested that they use it. So basically, here's what RAP is it uses mediation techniques to convert an appeals pre-conference into a working meeting for between appeals, LB&I, and the taxpayer. Now, and really the key difference between a RAP and some of the other ADR programs that appeals has, or that they run, is in a RAP. RAP is actually not even considered an ADR program. It's just considered a different way to do traditional appeals. And the reason is that the appeals officer in the RAP meeting actually has the authority to settle the case. In traditional mediation, that's not the case. The appeals person's in there acting as a mediator to see if you can come to some kind of an agreement, or the two sides can come to some kind of an agreement. With RAP, the appeals officer actually has the authority to institute a settlement. Now, RAP, as I said, has sort of been in the news a little bit the last little while, and I haven't seen any formal surveys or anything, but just talking to people, different practitioners and clients and such, I'm going to have to say that the initial thoughts that I'm getting back on RAP are not positive. And so, Shelley, why would someone want to actually participate in a RAP procedure?
Yeah, and that's, I mean, I've talked to a lot of, friends who are practitioners, and a lot of them have said that, they haven't used it and they probably wouldn't use it. But RAP is good for several, instances. I mean, it's just another arrow to have in your quiver. What it would be good for is if you have an issue that is continuing, so you want LB&I there to understand, how the settlement was arrived to, it'd be a good idea to have them there. It helps pinpoint the differences in either legal arguments or factual arguments between the taxpayer's position and LB&I's position. It gets the parties talking, maybe even more so than they did when they were in the exam process, and it really pinpoints for the appeals officer where they should look into that, and it really speeds up the process. Most RAP cases are resolved, at the first or second meeting. Sometimes, matter of a day and a half. And in fact, I was involved in one. I didn't even know I was involved in a RAP at the time. The appeals officer was just so good that we all just started talking, and by lunch the second day, the case was settled. And LB&I was on board with the whole thing. So it's very good. It's very inexpensive. It's very fast. There's no wasting of resources. I spoke to some people just this week who had been involved in one, and there was generally positive reception that they had as well. So those of you who've done it that are in the audience, if it's worked for you or not, why don't you send a question in so we can see what people have thought about their use of the rapid appeals process. But what it's really meant to do is utilize mediation and incorporate the mediation techniques into the normal traditional appeals process. And like I said, the one I was involved in worked really well.
So this next slide just lists some of the ADR programs that are currently available. We hadn't planned on taking a lot of time to go into these in any great detail because there have been some developments that we wanted to cover.
Right. And one thing, if I want to back up really quickly on the RAP, it's voluntary. So both sides have to want to do that. And if you're sitting at a RAP meeting and it's 10 o'clock and things aren't going well, or it's 2 o'clock and you're tired of hearing the other side talk, you can just stop it. And there's no downside risk to that. Nobody holds it against you for stopping it. These procedures have been around for quite some time, but they're not public. I didn't even know about RAP until I was over at Appeals, and I had to find out what is this. So they will be coming out shortly. They probably would have been out in the fall, except for the government shutdown. So I would hope that they'll be out shortly on that.
I put this slide up a minute ago. I think the next slide might answer a couple of questions that we have coming in. Or wait, I thought that we had a. Oh yeah.
Yeah, we did.
It's the receipts is what I wanted to go to. Let's look at these receipts really quick, and then we'll go back to some of the initiatives.
Yeah, these receipts. By looking at these, you would think, wow, SBSC fast tracks are doing great. Well, really, what that was is that during the fiscal year of 2013, when I was with Appeals, we made permanent a phenomenally long-lasting pilot. That pilot had to be around for maybe 6 years or something. And it was only available in 8 cities. And during the year of 2013, that was expanded, so by the end of the fiscal year, it's available nationwide. So the numbers went dramatically up, but it's primarily because now it's nationwide. But if you look at the LB&I stats, they're actually down, and there's some pretty good reasons for that. LB&I is trying to get resolutions at the lowest level there, so they're trying to resolve matters before they get to appeals. There are a substantial number of additional taxpayers that are in the CAP program, the pre-CAP and the CAP program, that would reduce the request for fast track. Although you still can use mediation when you're a CAP taxpayer. What other questions were there that related to that?
Someone had asked, let's see, I had requested for post-appeals mediation several times and was denied every time. What percentage of time a request for post-appeals mediation granted?
Yeah, I don't really know the answer for that. I know that a lot of people at appeals feel that that's just another bite of the apple, that you've had your chance with LB&I, you've had your chance at a fast track settlement, you've had your chance in traditional. So I don't know what the percentage are. They do happen. If you look at the statistics on the next page, they happen some, not a lot. But it is available, and if it's something that you think is, because litigation is extremely expensive, so any way that you can resolve, that you can reach a mutually agreeable resolution short of litigation is probably a good answer. But why don't we back up a little bit? Let's talk about the ADRs. Actually, what happened is that I was actually supposed to speak at the ABA tax section meeting in Boston back in 2012, I think. And I thought, well, while we're going up there, let's talk to the Harvard Negotiation and Mediation Clinical Program and let them look at all of the ADR procedures that appeals had and give them some ideas for how they can improve or change or modify what they have. And they presented a PowerPoint. I mean, and they gave there's 3 students and a professor and an assistant were available. And they did it all for nothing, so the government had absolutely no cost for that, and actually didn't even pay for me to go up to Boston, because I was going up there anyways. And they looked at it and provided a PowerPoint. It was, I forgot exactly how many pages, but it was a very, very long PowerPoint with a lot of recommendations. And Appeals has a team that's working on implementing many of the recommendations. I mean, some of them have to do with, deleting some that aren't used much, like fast-track mediation. Fast-track settlements used a lot. Fast-track mediation was not. Arbitration. I don't even know how many arbitrations were done in appeals. When I first got there, I asked people, and the 2 answers I got were 0 or 1. Now, I've told that to other people, and everybody said, well, they had 1, and they had 1. So I don't really know what the right number is, but it wasn't a lot. So they're looking at the types of ADRs that are available, and to make it easier for taxpayers to understand what's available and how to do them. And actually, one of the recommendations from Harvard was that the IRS had absolutely nothing on their website. Harvard suggested that they do that, and I think Troy just went online the other day and went and took that web page for a cruise.
I did. So it's pretty new. It was implemented in January of this year. So a couple days ago, I went on there and decided to put on my taxpayer/practitioner hat that I, of course, wear at all times anyway, and go for a little spin on the self-help tool, and I overall found it to be quite helpful. It's your typical online self-help tool where it asks you questions, and then depending on what your responses are, it forwards you to another screen, and it will help you navigate. It will help navigate you to the particular ADR program that would be the best for you. In the past, before this tool, I think that if you didn't know a lot about these ADR programs, you wouldn't even know where to look. You wouldn't even know they were available, or if there was anything other than traditional appeals that you could avail yourself of. Or you would have to, if you're a taxpayer or non-practitioner, you'd have to hire a practitioner to figure out what the advantages and disadvantages and the eligibility requirements for all of these are. This new tool helps with that. And then when you get to the page where it says, okay, fast track settlement is for you, then it has links to all of the applicable guidance on fast track settlement, the rev procs that have been issued. It tells you where you can look in the IRM for stuff about fast track settlement. So I did find that to be helpful. Now, I will say I did not attempt to call those toll-free numbers because I was not quite sure how long I had that night to stay in the office and stay on hold. But I'm sure that when you are able to get a hold of someone there, that the information is quite helpful.
Now, we have a question from somebody who said a few years ago they wanted to enter into a fast-track settlement with LB&I, at the right time after the NOPA was delivered, but the exam team said they couldn't do it because it was going to enlarge the cycle time. And that would have been true a couple years ago, but thanks to Heather Malloy, who's the commissioner for LB&I, she created something for her folks that they can. It basically puts a hold on the cycle time while the case is in fast-track settlement. So that helped, and that was one of the reasons why, if you would have looked at the increases in the fast-track settlements for LB&I in the couple years prior to 2013, they kept going up fairly dramatically. So that was true a few years ago, Mark, but it's not true now, hopefully. Okay, next, let's get to some real helpful hints for everybody, things that you can actually take with you and have more fun the next time you're with appeals. Well, Troy, if you know you've got several issues that were raised in the RAR, and some of those, let's say at least one of those, you don't think you have any chance or almost no chance of success. I mean, what do you do with that?
Personally, I don't do anything with it. I leave it on the table. I leave it in the trash. One of the things that I've learned, being just an advocacy lawyer in general, no matter what context that you're in, is your best asset is your credibility. And you don't want to lose credibility by throwing in some complete joke of an issue that you have, a 1% or less chance of winning. Why not just leave that out, gain some credibility with the appeals officer right up front? And so that's my practice tip there. Some of the other tips that we've got here are, I want to skip down to kind of how you prepare your protest overall, the order of issues, the strongest to weakest is kind of a general best practice rule. I don't know that that's always the best way to do it. Again, I've said this about 19 times during this presentation, is that I like stories. I like to tell stories. And so when I write a protest, I really like it to come across as a story, to start off with the facts and to present those facts in a way that the reader is going to follow along and hopefully understand what my position is, and then also start to become convinced that my position is correct. And then when I get into setting forth the authorities and the analysis of those authorities as applied to my facts, it just sort of all falls into place.
Well, at the paraphrase, I'm going to paraphrase Judge Mary Ann Cohen, who's a phenomenal judge. I like practicing before her, but to paraphrase something she said, appeals officers are people too. They want to understand. They want to know what's happening. They want to understand what's happening. When I write mine, I know I've written a good protest if I have some tear stains somewhere on the pages. You want to tell a story. You want to tell a compelling story. You want to have all the facts there. You want to provide anything that hasn't been provided in your protest, so that when the appeals officer reads it, everything is set. They won't have to send it back to you to ask you to do a more complete protest. Whether or not you should start with your strongest and go to your weakest, there's no set rule. You don't have to follow the order of the RAR. But what you should do is, if you're not going to follow the order, at least identify what issue you're talking about. So if the first issue you're going to talk about is the third issue raised in the RAR, just say RAR issue number 3, and you can deal with that first. I would almost never start with my weakest. Almost always start probably with your strongest. Someone asked, what is a skeletal protest? And you know what? I'm not exactly really sure. I've heard what people have said as a skeletal protest. What it really means, I think, is that you just give enough information there to meet your 30 days, and then appeals will ask you to fill it in. It's not much more than just skin and bones, which is why it's called skeletal. You're much better off doing a full protest, setting forth the factual analysis and your legal analysis, so that the appeals officer has that before they meet with you even.
Yeah, I don't think I've ever filed a skeletal protest. I think that I came close one time when we just took over the case and the 30 days was almost up for filing a protest, and there was just no way that we were going to be able to prepare a full, decent protest, and we didn't think we were going to get an extension, and so we just wanted to put something in there to meet all of the requirements. But it turned out, once we explained our situation to the appeals officer, we were granted an extension, so we were spared the skeletal protest.
One thing we had, a lot of people don't understand about personal and aggressive attacks on exam personnel. I mean, I've read a lot of people's protests, and I've read drafts of other folks' protests, and they constantly say that the revenue agent did this or said that, and people should actually understand that almost all appeals officers used to be revenue agents. They grew up with the revenue agents. They went to school with the revenue agents. They probably golf with the revenue agents if they golf. So, I mean, I don't even refer to it as the revenue agent makes findings. It's actually the government makes it. So I'll constantly refer to the RAR. So I don't talk about the revenue agent. I don't talk about their group manager. I don't talk about the economist, no matter what you might think about those folks. Just leave it as impersonal as possible, because you don't know who knows who and what hot button you're going to be pushing with that.
Yeah, that's good advice. Earlier in my career didn't understand that. Now I do. I'll just leave it at that. Some of the other points we have down here are actually kind of interrelate, and they go back to something that I said, I think, on the last slide, and that is a common error is so if you write a protest that does not stand alone, and I think what we mean by that is, again, you want to tell a story. You want to present your case in a document that the appeals officer can read and at the very least understand and be sympathetic to, and I guess in the best case they will shed tears and have to use your protest pages to wipe those tears from their cheeks. Now, when you do that, or what I'd like to do is do that, but you also have to make sure that you're addressing all of the arguments that that are brought forth in the RAR that the revenue agent's making, and you don't want to, in your goal of setting forth a standalone protest, you don't want to end up ignoring arguments that need to be addressed. And so I like to do my standalone protest as an initial draft, then go back through the RAR and make sure I have addressed all of the agent's arguments, addressed all of the authorities that he or she cites, and then sort of weave those in where they make sense into my overall story.
Yeah, weaving them in is a good idea. One last thing before we go to our last slide is that, a lot of times people think that they have to address each and every factual error that's in the RAR. I mean, there are going to be a lot of times where you provided information and the revenue agent either ignored it, forgot about it, misunderstood it. If it's important, you deal with it. If it's important, telling the story as to why the exam is and the taxpayer and why you're not in agreement, point it out. But you don't have to pinpoint each and every error in the RAR. But finally, I want to give everybody, best practices before an appeal. I should probably figure out 2 more, because I've got 8 here. If I got 2 more, then we could call these the commandments. But right now it's just 8, so I guess they're just suggestions on ways to make your next appearance before appeals go smoother. First one, just general, just be proactive. I mean, I can't tell you how important it is to communicate early, often, and as openly as possible. I mean, what I would do is, within a few days after the appeals gets the case, they have to issue what's called a uniform acceptance letter. And that uniform acceptance letter, it's going to be changing. Because I always thought that it was not that helpful. But the one helpful thing that was always on there was the name of the appeals officer and their phone number. So I would always call the appeals officer and talk about, the issue, even knowing that they probably haven't read my protest yet or the RAR. Talk to them, figure out what has to be done, get some time frames for when you're going to follow up and when they're going to follow up. Do that even at the conferences. Keep track of who's going to follow up and when they're going to do that, and stick with that, and make sure that the appeals officer sticks to that timetable. Be prepared to discuss issues even at the first meeting. A lot of people think that first meeting is just like a meet and greet. You wait for, or in a large case, you think it's just a pre-opening where LB&I is going to talk, and then everybody goes home. Be prepared at that first meeting to start.
Yeah, I'm just going to reiterate, be prepared. I've had experiences even on the phone, and not just at initial meetings, where I was calling the appeals officer to do what I thought was kind of schedule a meeting, and he said, well, okay, I've looked at your stuff, looked at your protest and your supporting materials. What is it you want me to do? Tell me why you're right and the agent's wrong. And he was, quizzing me right from the get-go. And so from that experience, I learned that it's important to be prepared as soon as possible. And then going right along with being prepared is, if you're at appeals, your case probably has some arguments that are not as strong as others. Be prepared to take those arguments head on, address those in your protest, and then, we can think about the challenges that are going to be made to those, the questions that the appeals officer is going to ask. Try to come up with all of those and come up with well-reasoned responses as to why, well, maybe this position is not as strong as another argument that I'm making, but it's still a very sound argument, and that's why we're putting it in the protest and bringing it before you.
Right. And when you go into a conference, be organized. Have each, if you got multiple issues, have each issue outlined, know what the facts are, know what both sides' arguments are. Be open. I mean, if unless you have a 100% chance of success, well, first, if you have a 100% chance of success, you don't really need to worry about those ADRs. But if you don't have 100%, make sure that you and everybody else at your office knows what the hazards are. We've been able to answer most of the questions sent in, not all of them. For those that we were unable to answer during this program, which I think is we're at the ending point about now, we will get back to you. So we've got your email address and your name, so we will definitely get back to the folks who we weren't able to address as we were going through the program. Remember, if you want your CLE credit, the password is appeals. And Troy and I really want to thank everybody for participating today.
Yes, thank you very much.
Thank you for attending Sutherland, Asbill, and Brennan's LLP's webinar. Current update on IRS Appeals Divisions and other acronyms, including AJAC, RAP, ADR, and NII. As a reminder, CLE evaluation forms and sign-in sheets will be sent to you after the webinar.